Greetings, royal queens and kings. It's your host, Queen Tosa, and welcome back to the Queen Tosa Show. I will actually be your captain tonight. It's a lot going on with this whole Jeffrey Epstein situation, and we are definitely going to go through the documents. But before we get into the documents, let's go ahead and get into our greeting, and we'll be right back.
Never say they want it. Girls can't never say yeah. Girls can't never say they need it. Girls can't never say nah. Girls can't never say they want it. Girls can't never say yeah. Girls can't never say they need it. Girls can't never say nah. Oh nah. Give it to me like you need it, baby. Want you to hear me screaming, have it breathing. I don't need a reason, baby. I want it till you can't vibe. I can get it to you right, baby.
All right, you all, we are definitely back, and we are going to go through this list. It was released on January the 3rd of 2024. And we're going to get through as much as we can. We do have a show like right after this. So let's go ahead and get into it. The Honorable Loretta A. Preska, District Court Judge, United States District Court, Southern District of New York, 500 Pearl Street, New York, New York, 10007. Godfrey Maxwell, case number 15 CV 7433 dash LAP. It says, Dear Judge Preska, pursuant to the court's December 18, 2023 unsealing order and following conferral with defendant, plaintiff files this set of documents ordered unsealed. The filing of these documents ordered unsealed will be done on a rolling basis until completed. This filing also excludes documents pertaining to those 105 see December 28, 2023 email correspondence with Chambers 107 and 110. ECF NO 1319 while the court's review of those documents is ongoing. Okay, so we're on Exhibit 4. Okay, so this is a email from gmax1 at elimax.com. And it was sent Saturday, January 10th, 2015 at 9 a.m. to Philip Barton Ross. Go. I'm out of my depth to understand defamation and other legal hazards and don't want to end up in a lawsuit aimed at me from anyone if I can help it. Apparently, even saying Virginia is a liar has hazard. I have never been in a suit, criminal or civil, and wanted to stay that way. The U.S. lawyers for the Jane Does are filing additional discovery motions, and if I speak, I open myself to being part of discovery, apparently. I am trying to stay out of litigation and not have to employ lawyers for years as I get lost in U.S. legal nightmare. I stand on legal risk currently on these old charges in civil suits against Jeffrey. We need to consult with U.S. lawyers on any statement I make and the complaints to perhaps we make a statement of the legal risk of saying anything for potential defamation or something that prevents a full and frank detailed rebuttal. Plus, the press not being the place for that. Regardless, Philip, please call Jeffrey lawyer and see what you can understand from him and perhaps craft something in conjunction with him. Either way, I think you need to speak to him to understand my risk so you can help me understand it too. I have already suffered such a terrible and painful loss over the last few days that I can't even see what life after Press Hill even looks like. Statements that don't address all just lead to more questions. What is my relationship to Clinton? Andrews, on and on. Let's rest till Monday. I need headspace. Okay. So that's the Terramar Project, Facebook, Twitter, Google Plus, Pinterest, Instagram Pledge, Daily Catch. Okay. Oh, excuse me. All right, let's get in here. Virginia L. Guffrey. Here, let me put on some relaxing music for those of you that are out chilling with us tonight. I pray that you all are feeling amazing tonight as we go through these documents one by one. Okay, so Virginia L. Guffrey is a plaintiff and Ghislaine Maxwell is a defendant. I don't know if I was saying her name right, but plaintiff's motion to compel defendant to answer deposition questions filed under seal. Plaintiff Virginia Guffrey by and through her undersigned counsel hereby files this motion to compel defendant to answer deposition questions during her recent deposition. Defendant refused to answer numerous questions about allegedly adult blank activity related to Jeffrey Epstein. Because this activity is highly relevant to this case, defendant should be ordered to answer questions about it. As the court is aware, this defamation case involves Ms. Guffrey's assertions that she and other females were recruited by defendant to be blank A by Jeffrey Epstein under the guise of being massage therapists. See complaints DE 1 at 27. Guffrey described Maxwell's role as one of the main women who Epstein used to procure underage girls for blank activities and a primary co-conspirator and participant in his blank scheme. In response to these assertions, defendant has made the sweeping claim that Ms. Guffrey's assertions are entirely false and entirely untrue. Complaint DE 1 at 31. Defendant has labeled her entire deposition transcript as confidential at this time. Counsel for the parties conferred at the deposition regarding answering questions. Yet during her deposition, defendant refused to answer any question that she construed as having something to do with consensual adult blank. Defense counsel supported that position that frankly, that's none of your business, and I instruct the witness not to answer. See Declaration of Sigrid S. Macaulay, DEC 1, Exhibit 1, TR of Maxwell Depot, April 22nd, 2016 at 21. The result was that a number of points throughout her disposition, defendant refused to answer questions about subjects integral to this lawsuit, including questions about the alleged massage therapist were doing all Jeffrey Epstein's house and the blank nature of the massages. For example, defendant refused to answer questions about whether she had given Jeffrey Epstein a massage. Question: have you ever given Epstein a massage? Mr. Pagluka object to the form foundation, and I'm going to instruct you not to answer that question. I don't have any problem with you asking questions about what the about what the subject matter of this lawsuit is, which would be, as you termed it, blank blank of Miss Roberts. To the extent you are asking for information related to any consensual adult interaction between my client and Mr. Epstein, I'm going to instruct her not to answer because it's not part of this litigation and it is her private confidential information, not subject to this deposition. Ms. McCauley, you can instruct her not to answer. That is your right, but I will bring her back for another deposition because it is a part of the subject matter of this litigation, so she should be answering these questions. This is civil litigation, deposition, and she should be responsible for answering these questions. Mr. Pagolica, I disagree, and you understand the bounds that I put on it. Ms. Cawley, no, I don't. I will continue to ask my questions, and you can continue to make your objections. Question: did you ever participate from the time period of 1992 to 2009? Did you ever participate in a massage with Jeffrey Epstein and other female? Question: Mr. Pagolica, objection, do not answer that question again to the extent you're asking for some sort of illegal activity as you construed in connection with this case. I don't have any problem with you asking that question. To the extent these questions involve consensual acts between adults, frankly, they're none of your business, and I will instruct the witness not to answer. Ms. McCauley, this case involves blank, 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 blank. Questioning about her having interactions with other females is relevant to this case. She needs to answer these questions. Mr. Pagolica, I'm instructing her not to answer, Ms. McCauley. Then we will be back here again. See, Ms. McCauley, DEC 1 at Exhibit 2, TR of Maxwell Depot, April 22nd, 2016 at 19 through 22, emphasis added. Defendant's participation in massages with Epstein is a central part of this case. Ms. Jeffrey has explained that during her first blank encounter with Jeffrey Epstein, it was defendant who provided instruction on how to do it and how to turn the massage into a blank event. Obviously, proof that defendant had previously massaged Epstein includes massages with blank component would provide important corroboration for Ms. Guthrie's testimony at trial, and proof that defendant was involved in massages will further prove that statements to the press that Virginia's allegations were obvious lies was itself an obvious lie. Another example, defendant refused to answer questions about her knowledge that Jonna Schberg was hired to work for Epstein and provide massages. In the police report, Joanna admitted that Maxwell recruited her to work for Epstein. See McCauley, DEC 1 at Exhibit 3, Guthrie 000076-77, police report indicating that Joshana was recruited by Maxwell. Yet during the defendant's deposition, she refused to answer questions regarding Joanna Schomburg. Question: do you know what task Joanna was hired to perform? A, she was tasked to answer telephones. Question: did you ever ask her to rub Jeffrey's feet? Answer: I believe that I read that, but I don't have any memory of it. Okay, so we are still going. Let me check you all in the chat, see how you all are doing. Okay, how are we doing out there? Are you guys enjoying the content? Are you enjoying the content? Let us know how we're doing. We always love to know how we are definitely doing. Okay, so here, maybe I should put this right here and then you guys could kind of see my background. And then what I can do is I can like kind of like add this up a little bit. Okay, let me open this up a little bit. And then actually I'll put that right there. And then we can save. Okay. All right. So let me know if you guys are enjoying the content. All right. Let me see. We have Wani11 in here. Hello, Wani11. We have Wani11 says, please like, share, subscribe, and join the combo respectfully. And also, no problem. Hit that Cash App, $7070707. Wani11 says, yes, ma'am. Hey, Norris Tony. Norris Tony has definitely showed up tonight. Thank you for showing up, and definitely check him out. He's a content creator here on YouTube. All right, so question. Did you ever tell Joanna that she would get extra money if she provided Jeffrey massages? That was a question. Answer. I was always happy to give career advice to people, and I think I did that becoming somebody in the healthcare profession, either exercise instructor or nutritionist or professional massage therapist, is an excellent job opportunity. Hourly wages are around $7, $8, $9. And as a professional healthcare provider, you can earn somewhere between, as we have established, $100 to $200. And to be able to travel and have a job that pays, that is a wonderful job opportunity. So in the context of advertising, the context of advising people for opportunities for work, it is possible that I would have said that she should explore that as an option. Question. Did you tell her she would get extra money if she massaged Jeffrey? Answer. I'm just saying I can't recall that exact conversation. I give career advice and I have done that. Question. Did you ever have Joanna massage you? Answer. I did. Question. How many times? Answer. I don't recall how many times. Question. Was there blank involved? No. Question. Did you ever have blank contact with Joanna? Mr. Paluca. Object to the form and foundation. You need to give me an opportunity to get in between the questions. Anything that involves consensual blank on your part, I'm instructing you not to answer. Question. Did you ever have blank contact with Joanna? Answer. Mr. Paglica. Again, she is an adult. Question. I'm asking you, did you ever have blank contact with Joanna? Answer. I've just been instructed not to answer. Question. On what basis? Answer. You have to ask my lawyer. Okay, so C. McCrawley, DEC1 at Exhibit 4, TR of Maxwell DEPO, April 22nd, 2016 at 60 to 62, emphasis added. So that was in the deposition, I'm assuming. Okay, here again, this information is critical to the case. Among other things, these questions are designed to show a modus operandi, MO, for Epstein and Maxwell, specifically how they recruited for non-blank massage that converted the massage into blank activities. One last illustration comes from defendant's refusal to answer about her knowledge of Epstein's blank interest during massages. Question. Does Jeffrey like to have his nipples pinched during blank encounters? Mr. Paglica. Objection to form and foundation. Answer. I'm not referring to any advice on my counsel. I'm not talking about any adult blank things when I was with him. Question. When Jeffrey would have a massage, would he request that the masseuse pinch his nipples while he was having a massage? Answer. I'm not talking about anything with consensual adult situation. C. McCrawley, DEC1 at Exhibit 5, TR of Maxwell deposition, April 22nd, 2016 at 82. While Epstein himself might also provide answers to these questions, it appears likely that he will assert his Amendment privilege regarding his blank activities. Accordingly, Ms. Giffrey must pursue questioning of Maxwell to obtain information on this subject. Here again, information about Epstein's blank idiosyncrasies. Hold on. Idiosyncrasies will provide important corroboration to Ms. Giffrey's testimony that she had blank interactions of an identical nature with Epstein. These refusals are not an isolated instance. Instead, similar refusals to answer questions occurred repeatedly throughout the deposition. CEG Macaulay Dale 1 at Composite Exhibit 6, 52 through 55, 64 through 65, 82, 92 through 93, 137 through 138, 307 to 09. The court should compel defendant to answer all these questions in addition to the specific points made above. The big picture here reveals how vital such discovery is. At the core of Ms. Giffrey's allegations is the allegation that defendant lured her into a blank situation with the offer of a job making money as a massage therapist that Epstein always habitually tried to turn massages into blank. That was his modus operandi, and plan all along, and that Maxwell recruited other females for an ostensibly proper positions such as therapeutic masseuse, with knowledge that the intent was for that person, for that person would be pressure to provide blank gratification to Epstein. As a result, Epstein's use of massages for blank purposes is a central part of this case. And defendant's role in those massages and knowledge of the purposes of those massages is a critical piece of evidence showing her state of mind when she attacked Ms. Giffrey's assertions as entirely untrue. Ms. Giffrey intends to prove at trial that defendant knew full well the blank purpose for which she was recruiting females, including underage females like Ms. Giffrey. Ms. Giffrey is entitled to explore defendant's knowledge of the blank activities that took place under the guise of massages. Otherwise, defendant will be able to portray the jury an inaccurate picture. Otherwise, defendant will be able to portray to the jury an inaccurate picture of what was happening at Epstein's house. What nothing more than run-of-the-mill massage therapy. CEG Macaulay DEC 1 at Exhibit 7, CR of Maxwell deposition, April 22nd, 2016 at 51. Question: did the pay-for massage therapist vary on blank acts they performed? Answer: no, it varied depending on how much time. Some massage therapists charge more and some charge less. Defendant's refusal to answer questions about alleged adult consensual blank also blocks Ms. Giffrey from seeking legitimate discovery in this case by refusing to answer questions about her and Epstein's blank activities with alleged adults. Defendant is essentially given the ability to refuse to answer any blank question she does not wish to answer. Defendant simply has to deem the question as involving consensual adult blank and no need to be given. The result is to leave Ms. Giffrey with no way of exploring the identity of these alleged adults, the ages of these alleged adults, and indeed whether they were all adults. This allows the defendant to claim that she is unaware of any blank activity involving underage females because she claims the only blank activity she was aware involved adults. The court should compel Ms. Maxwell to answer all questions about her knowledge related to S activities with Epstein and other females while at Epstein's various homes. See FEDRCRIM P37A3BI Kelly VA1 Tech number 09CIV.962 LAK MHD 2010 WL1541885 at 20 SDNY APR 12 2010 under the federal rules. When a party refuses to answer a question during a deposition, the questioning party may subsequently move to compel disclosure of the testimony that is sought. The court must determine the propriety of the deponent's objection to answering the questions and can order the deponent to provide improperly withheld answers during a continued deposition. Internal citations omitted. Of course, the party objecting to discovery must carry the burden of proving the validity of its objections, particularly in light of the broad and liberal construction afforded the federal discovery rules. John Wiley and Sons Incorporated versus Book Dog Books LLC 298F.R.D. 184-186 SDNY 2014 of a deposition in. Okay, so for purposes of a deposition, the information sought need not be admissible at the trial if the discovery appears reasonably calculated to lead to the discovery of admissible evidence. Chin Ulster versus Goldman Sachs and Co. 293 F.R.D. 557561 S.D.NY.N.Y 2013, citing Fed.R.CIVP 26B1. Defendant cannot carry her burden of showing that the questions asked are not reasonably calculated to lead to the discovery of admissible evidence. This is a case in which blank activity, S activities, lie at the heart of the issues in dispute. As a result, it is hardly surprising to find that discovery pertains to alleged adult S activities and questions about subjects are entirely proper. SEEG CONDIT VDUNNE 225 F.R.D 100 113 S.D.N.Y 2004. In defamation case, plaintiffs hereby ordered to answer questions regarding his S relationships in so far as they are relevant to the defense of substantial truth, mitigation of damages, or impeachment of plaintiff. Weber versus Multimedia Entertainment Incorporated, number NO.97 CIV.0682 PKLTHK, 1997 WL729039 at number 3 SD S.D.N.Y November 24th, 1997. While discovery is not unlimited and may not unnecessarily intrude into private matters, in the instant case, inquiry into private matters is clearly relevant to the subject matter of the suit. Accordingly, plaintiff Misty Weber shall respond to defendant interrogatories concerning her as partners. Generally speaking, instructions from attorneys to their clients not to answer questions at a deposition should be limited to issuing regarding privilege. Morales versus Zondo, Incorporated 204 F.R.D 5054 S.D.N.Y 2001. In this case, defense counsel ranged far beyond the normal perimeters of objections and sought to decide for himself what issues were relevant. That was improper, and the court should order a resumption of the defendant's deposition so that she can answer questions about her knowledge of S activity relating to Jeffrey Epstein. All right, so let's get to the conclusion. Defendant should be ordered to sit for a follow-up deposition and directed to answer questions regarding her knowledge of alleged adult S activity dated May 5th, 2016, and that was signed, respectfully submitted by Boys, Skiller, and Flexner, LLP, and that was definitely signed. Okay, so we're already on page 11. Let's see what's next. So what comes up next? Okay, so there's a address that's provided, right? So you have 333 Main Street, Armonk, New York, 10504, Riley J. Edwards, Pro Hack Vice, Farmer Jaffe, Westing Edwards Vistos, and Learman PL, 425 North Andrews Avenue, Suite 2, Fort Lauderdale, Florida, 33301. Paul G. Gasso, Pro Hack Vice, S.J. Quinney, College of Law, University of Utah, 383 University Street, Salt Lake City, Utah, 84112. Okay, so they got that information right there. And pretty much it says, this daytime business address is provided for identification and correspondence purposes only and is not intended to imply institutional endorsement by the University of Utah for this private representation. Okay, so here's a certificate of service. I hereby certify that on the 5th day of May 2016, I electronically filed the foregoing document with the clerk court by using the CMECF system. I also certify that the foregoing document is being served this day on the individuals identified below via transmission of notices of electronic filing generated by CM/ECF. Okay, so this guy, Laura A. Menninger, Jeffrey Pelagica, Haddon, Morgan, and Foreman PC, and it has their address. It's been signed. Okay, so now we're on to Exhibit 4. Are you guys enjoying the commentary? Are you guys enjoying the commentary? Okay, so 111 says, hey, Norris Tony. Hey, 111. Yes, blessing. The queen is here. Hello, everybody, for 2024. Thank you, Joseph, for the heads up and encouraging worship. My Norris. Hey, Winnie. Hello. I'm glad. Oh, you watched the worship video for the new year? Getting into it, missionary, laying all my cards on the table if you guys are interested. All right. Thank you so much. Tonight we're working on the Jeffrey Epstein story. But you can always email me or send me a text. My number is 405-437-4865. You can always send me a text there. If I don't answer right away, just give me time to respond. Okay, so we have another show at 11, right? So I'm thinking that we should just ease into this. This is going to be like a part 2 because you all, this is like 943 pages. This is going to be like 943 pages. And it's going to be a lot. So I just want to like coast myself through it. I want to coast myself through it. I do know that we do have another show here coming up in a little bit. So just so I don't overcloud myself and get overwhelmed, I think that this is a safe place to, call it safe to stop. And what we'll do tomorrow is we'll go ahead and we'll start from page 14. And this is going to be the Virginia L. Giffrey against Ghislaine Maxwell, so Miss Maxwell. So this is going to be like confidential. Right here it says videotape deposition of Ghislaine Maxwell taken pursuant to subpoena. So it's going to be a lot. So this is going to be page 1. We just got through the introduction tonight. So if you guys feel like this is a safe space to kind of like, kind of a safe way to park, and then we can come back to it. What do you all think? Is it a safe place to park and we come back to it tomorrow and we can really get into page 1? I think that that'll be appropriate. You guys make sure you come out for the show tonight. We will be here shortly. Yes, ma'am. Okay. So yeah, we'll get back up on that tomorrow and we'll start from page 1. But tonight we've got the official trailer. Put on a dress. Okay. I need you all to get your popcorn. I need you to get your bottles of water. I need you to be hydrated. I want you to feel your best. Okay, I want you to feel your best. I want you to come very relaxed because we are definitely going to, Cat Williams is definitely in the news. And there are some people that don't agree with him. There are some people that do. And I just feel like it's a topic that we definitely need to address. And it's going to take us by storm, And my thing is, when it's time for somebody to step up and say their truth, we don't get the right to tell them, well, leave that part out, or don't mention that part, or don't bring up that experience. We don't get the right to do that. Okay? So just as well as in this Jeffrey Epstein case, it's a lot that we're going to be unpacking. And I want to give you guys a trigger warning and prepare yourself before we get into page 1 tomorrow. So I want you guys to do like a cleanse, a mental cleanse, and do whatever it is that you have to do to protect yourself. If it becomes overwhelming to you, feel free to step away. Keep us playing, put us on mute, but just step away, So yes, we will be back here shortly. Set those notifications. I love you all. Let's have a pleasant evening on purpose. Until next time, so long.